Good morning. The court is now in session. So that means you all have to be extra quiet. We have 3 judges here. Good morning, everyone. My name is Ed Davis. I'm with the law firm of Astigarraga Davis here in Miami. I have the pleasure of and privilege of serving on the advisory board for Offshore Alert, and we have the pleasure and the privilege of having 3 extraordinary justices here to assist us in understanding legal developments in the offshore world. I don't know what it says in your program about what the title of this is, but that's not what we're doing. So let me tell you what we're doing. We're doing legal developments in cross-border litigation and asset recovery. And we know that that appeals most broadly to this audience, and so we have the, as I said, extraordinary privilege to have 3 sitting judges here who are, think about that, who are willing to come in and share insights with regard to cases that they've handled or been involved in over since this time last year. And that's a very rare occurrence, and so let me, and we want to encourage them to keep doing this. So I'm going to ask you to do something different than we do in most cases when you applaud at the end. I'm going to ask you to applaud at the beginning and thank them for coming here. Let me introduce our panel. Our panel will start with Justice Neville Adderley, who is with the Court of Appeal of the Bahamas since 2012. Before that, he was a Supreme Court justice in the Bahamas at the trial level. He will take us through some general principles that have come out of some recent cases, and then take us through 2 specific cases from the Bahamas. After Justice Adderley, we will have Justice Edward Banister. He's the commercial court judge of the Eastern Caribbean Supreme Court and sits in the BVI, and he will take us through 3 cases of import, and you will see a theme develop out of these cases that we've selected to talk about. And then lastly, Chief Justice Ian Kawaley of the Supreme Court of Bermuda. And I've had the pleasure to instruct counsel before all 3 of these courts, and we are lucky to have 3 of the most important jurisdictions in the offshore world to be represented here by their justices. And I'm going to have the luxury, which I normally, when you're a lawyer standing at the podium before court, you'd never, ever interrupt the judge. I've got permission to interrupt them today. And I'm going to ask them questions. Normally they're asking me questions. So this is a rare thing for me, so I'm going to enjoy every minute of it. But I'll be sparing Justice Adderley with regard to my interruption. So without any further ado, let me introduce again Justice Neville Adderley, and he'll take us through some developments in the Bahamas.
Thank you, Ed. I am honored to have been invited again to this well-organized and informative conference. This morning I will deal with cross-border asset recovery, and that is a complicated topic that really should be allocated about 3 to 4 hours. But have no fear. I say to you, like King Henry VIII said to his 5th wife, I won't keep you long. In fact, I won't keep you longer than the 25 minutes that they have allocated to me. Cross-border asset recovery normally takes place under one of 2 regimes. One, the criminal regime. But I should have a little
Clicker? Oh. Do we have somebody in the back? Oh, there we go. Pardon? Oh.
Was it? Oh.
Here it is. This thing.
Yeah.
I would imagine the big green button.
Oh.
That should do it.
Okay. Sorry about that. One, the criminal regime in which a foreign government is attempting on its own behalf or on behalf of victims of crime to recover assets determined to have been obtained from the proceeds of crime. And 2, the civil regime, either when private individuals wish to recover the fruits of their judgment in a foreign country, or where proceedings are instituted by regulators in one country to assist victims of fraud in their country to recover assets of wrongdoers located in other countries. Now, at the risk of oversimplification, I might nevertheless at the outset, try to briefly set out the bare bones of the general principles and processes so as to be more easily recognized when we discuss the cases. I recognize that for some of you, being senior practitioners, this might be treading on familiar ground, and so for that I apologize. Dealing first with the civil regime, this consists of two parts, statute and the common law. In the Bahamas, the statutory provisions are embodied in an act called the Reciprocal Enforcement of Judgments Act. No doubt there is a similar act in most of your countries as well. The act allows a person to register a judgment in a country with which their country has an agreement to do so. And there's a clearly laid out registration process. The limitation on the Reciprocal Enforcement of Judgments Act is that most countries, including the Bahamas, have a limited number of countries with which they have agreed the judgments can be reciprocally enforced. In the case of the Bahamas, for example,